My sister and I own a cabin. Do I want the cabin going from me to my sister through joint tenancy to the exclusion of my family? Probably not. My kids would be out of that cabin. So we want tenants in common, meaning I own an undivided half interest and my sister owns an undivided half interest. So if I die, half the cabin is part of my estate. If my sister dies, half of the cabin is part of her estate. We don't want joint tenancy there. So a lot of times, joint tenancy is there for married couples because you don't want to exclude the decedent's family. Very important, though. A lot of people assume that the property is in joint tenancy or assume that it's titled as tenants in common, and the title company didn't do it the way everybody assumed. So the moral of that story is check if you're on title with somebody, especially a cabin or a piece of land or investment property, make sure you checked how the deed reads. Is it joint tenants with rights of survivorship, or is it tenants in common? On occasion, you'll see property conveyed where someone will retain a life estate. We don't see this as much anymore because there aren't the medical assistance or nursing home planning benefits we used to have. But my mother could have a property and convey it to me, gift it to me right now, but retain a life estate. So during her lifetime, she still controls it. Like I said, they're not as common anymore, but you might see retained life estate. So what happens if I simply develop a plan in my will or my revocable living trust that conveys the property directly to my kids? Well, I probably want to make sure it's conveyed to them as tenants in common. So my 3 kids each inherit an undivided 1/3 interest, and it's not to the exclusion of their children. What's the benefit of that? Well, the benefit is it happens automatically. Boom, my estate is settled, goes to them. What's the drawback? Well, guess what? They're in the co-ownership business. There's no plan. We have 3 kids. So what if one wants out? What are they going to do? Nothing, really. Can they force the sale? Not really. It's very difficult. The real estate laws are very, very difficult to basically allow for what's called a partition action. So they've got to negotiate some kind of a buyout. What happens if they're having trouble getting one party, getting money from one party to pay the bills, pay the real estate taxes, pay the insurance? Again, somebody's got to pay it, or they're all 3 in trouble. They could potentially lose it. So direct transfer of ownership under certain circumstances may not be the best option. What are those circumstances? Well, when there are multiple beneficiaries. And I'll tell you, if there's more than 3 beneficiaries, there's almost always a problem. You almost always see difficulty in getting the group to get along and make the right decisions. If there's just one beneficiary, one child, that's fine. You don't need to do it any other way. But direct ownership oftentimes creates issues. All right, so what do you do about that? Well, a lot of times for many years, people have been using the cabin trust option. What does that mean? That means instead of direct ownership, you're going to create a plan. And that trust is going to lay out that plan. Well, what's that plan? Well, the first thing that trust might say is obviously who's responsible for it? Who's the trustee? Who's going to govern that trust? It could be one party. My wife and I have 3 kids. It could be all 3 kids as trustees with a majority vote. There are certain reasons why you might want to have one make all the decisions, and there are reasons why you might want to have them all together, but really those are going to be more associated with your understanding of the parties and who would be best to handle the property. But governance who's responsible. That's a key reason for a trust. You don't have those direct ownership issues anymore. There's somebody handling it. And then, what about just normal administration concerns? You would lay it out in that trust. How to handle expenses. How to deal with decisions. What if you need a roof? What if one party doesn't want to pay to have the docks taken out and the other does? Well, you have basically a governance or a dispute resolution plan within the trust. The next reason, the most common reason, is succession. What happens if somebody wants out? Well, typically we would have some buy-sell provisions in the trust. We would have some provisions that basically talk about how you remove or buy out a departing party, whether it's they just want out or whether they become disabled or they die. And what happens oftentimes is it's based on your intent. If I create a trust and it's my objective to make sure that that cabin stay in the family for future generations, I'm going to be pretty tight with that trust on how succession flows. I might not give the option to allow a party to be bought out. Or I certainly, if I'm giving the option, I might make sure that they're taking a pretty healthy haircut when they're bought out. I might require that it only travels down the bloodlines, doesn't go to spouses, only goes to grandkids, great-grandkids, their children, if that's my objective. But what if I don't care about any of that? Well, then I might obviously not have such restrictive provisions. So again, it depends on what your intent. One of the things I'll get into toward the end, one of the best practice tips is communication. I can't tell you how many times over the years I've met with families, with my client first, and they say, the kids want it. They want the cabin. And then all of a sudden, boom, I say, all right, let's get everybody involved. They don't want it. Kids don't necessarily want what we want nowadays. And that's anything from your personal property to your real estate. They'll take your money, but they don't necessarily want your personal property or your real estate. So you don't want to develop a grand plan if they don't want it. So communication is important. Do they want the property? You might have a kid that married into a family that has a cabin, and they enjoy going to that cabin. Are they really going to want yours? And are they really going to want to pay for yours when they're paying for another one? So communicate, find out who wants what, and that's part of the plan. So the downside to cabin trusts is cabin trusts are oftentimes, they lack flexibility, because many times these trusts are irrevocable. So different than this revocable living trust I was talking about for your estate, an irrevocable trust is a trust that can't be changed. Why would I do an irrevocable trust? Well, for tax purposes, I might want to remove the asset from my estate. So let's say the cabin is worth $500,000. If I remove the asset, if I give it to an irrevocable trust where my kids are the beneficiaries, I'm taking a $500,000 asset out of my estate for tax purposes, plus all the future appreciation of that property. So if I live another 20 years and that $500,000 cabin is all of a sudden $1.2 million, that's a $1.2 million asset that's out of my estate. I can't do that with a revocable trust. I can't do that and retain control of it. It has to be in an irrevocable trust. So I created this irrevocable trust, and then all of a sudden I can't change it anymore because it's no longer mine. So trusts can be less flexible rather than the next option we're going to talk about, which is a cabin LLC, or limited liability company. I would say 80% of the time, for the last 10 years, we've been doing LLCs rather than trusts. And there are two primary reasons for that. They do the same thing. They have all the objectives that I just mentioned: governance, plan for succession, keeping it within the family with heirs rather than in-laws, expense payment strategies, buyouts. All of that is the same planning, whether it's in a trust or an LLC. The difference is an LLC, even though I gifted the interest, it can be much more creative. I could retain 1% and give the kids 99%. So I'm getting 99% of the value out, but I can still retain the governance, the control. So that's one strategy. With an LLC, it's not irrevocable. The operating agreement, or what we refer to as bylaws in a normal corporation, can be changed anytime. It depends on the terms of the operating agreement. A lot of times it's by a majority of the interest holders in the LLC. Sometimes it's left to a certain party to be able to change it. But the main point is, if the interested parties agree that things need to be changed, it can be changed. With an irrevocable trust, you can't do that. The other reason why a lot of people are doing LLCs now is there's greater liability protection. It's a corporate entity. It has a liability shield. Even though oftentimes, and let's assume you're not renting the cabin through Airbnb or VRBO, even though it's not an income-producing asset, you can term it as an investment property. Even though it's a personal residential property, you can still put it in an LLC. So if I'm sued as a result of that property and the insurance company doesn't pay the claim, or I have insufficient coverage, they can't pierce the corporate veil, meaning they can't sue me personally. They can only take the cabin. And guess what? Recreation property is the #1 potential risk. Jet skis, people falling off of decks, accidents, maybe even property that you're not surveying as much as you should. Maybe there's a barbed wire fence and snowmobiles that go through it. Maybe who knows what the issue is. But if for some reason your insurance company doesn't pay the claim, it's great to have this LLC in place because that's protecting your personal assets. So the main reason LLCs are more popular is just flexibility. And an LLC doesn't take away your need for proper liability protection, but it bolsters that protection if you have an issue with your coverage. Either the accident is outside of the scope of the coverage, or you don't have enough coverage relative to the claim. Now, what's the downside to an LLC? Well, it's more involved and it's more costly. We go back to option 1, direct ownership. There's no cost there. That's basically being conveyed directly. It's filing a deed. It's nothing. A couple $100. It's not no cost, but it's very nominal. Doing a trust, that's more involved. That's basically either me as the client saying, okay, this is how it's going to be done, boom, 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 or me meeting with my family and my lawyer and all of us meeting together and coming up with a plan. It depends on how detailed the plan is. But on average, a couple $1,000 minimum to do a cabin trust. With an LLC, the actual formation costs aren't that much higher, but keep in mind that there's more administration. So you're forming a corporation under Minnesota law. That means it's got to be filed with the Minnesota Secretary of State. Name's got to be cleared. You got to pay the filing fee, which is close to $300. But then every year around this time in the fall, you got to tell the state of Minnesota that you plan to be an LLC next year. Otherwise, your corporate status goes inactive. You don't have any of that stuff with a trust. So it is more costly and more time consuming, not much more. There's just more to it. Now, in exchange, you're getting more out of it. You're getting more liability protection. You're retaining more flexibility for changes. And it's easier with succession planning. If I want to hold 50% of the value of the cabin, give 50% to my kids, and then down the road, I want to give that other 50%, it's easy. I just create a new stock certificate for the LLC, one form, and it's theirs. I can't do that with a deed with a fractional interest very easily, and I certainly can't do that with an irrevocable trust. So there's just more flexibility with an LLC. And like I said, the liability protection is more detailed. So I mentioned this earlier, communication. Make sure if you're creating a cabin plan, the interested parties are in line with your objectives. Make sure they want it. And then talk to them more in depth about what happens. Is it going to be your plan? Where you're going to say, hey, it's going to happen X, Y, and Z, and there's no alternatives? Or is it going to be collectively the plan for everybody? You're going to hear from them. You're going to hear from them what they want to have done with their share. Maybe they do want to leave it to their spouse. And maybe you end up being fine with that. So communication is very important. But you also want to look at the tax side of this. What if I decide to give the cabin to my kids today, and I don't really care if they sell it when I'm gone. I just want to make sure that they get it. Well, there's a tax consequence to me giving it to my kids. The first tax consequence is gift tax related. If that's a $500,000 property and I give them a $500,000 asset today, I can only give an individual $16,000 in a given year without gift tax. So I have to use a portion of my lifetime exemption from estate and gift tax. Now I can't just do that. I have to file an informational form IRS Form 709, a gift tax return, to use a portion of the excess gift that normally would be taxable. So the main point is when you give anyone more than $16,000 in a given year, there can be tax consequences. Now this is an informational gift tax return. I don't owe any tax, my kids don't owe any tax, but it can't be a tax-free transaction unless I file that gift tax return.
If you have one child, do they get the $16,000, or if you have 5 children, does each one get
each one?
16?
Yeah.
It does.
And then collectively, if you're married, 32 for each.
That's going up next year, right?
Yeah.
To 17.
Yeah. Well, they haven't confirmed it. They said it's going up. They haven't just confirmed whether it's 17 or 18. Yeah. So, but that's the first issue, is the transfer from me to my kids during my lifetime is a potentially taxable gift. The other issue is income related to my kids. It's not income that they declare on their tax return, but they receive my cost basis in the property. It's called carryover basis. So if that property is worth $500,000 today and I bought it for $100 way back when, their new basis in the property is $100, not the $500 when I gave it. So when they turn around and sell it, they owe capital gain all the way back to the $100 that I purchased it for, versus if I have it go through my revocable living trust to them upon death, that gain is wiped out. There's what's called step up in cost basis. So the question oftentimes with these gifts is, what's the timing of the gift? Will they sell it? And what's the best way to do it? Sometimes it's better to hold assets in the estate, but the drawback to that is you're keeping the assets in the estate and you might be subject to estate tax. So The main point to all of this is when you're dealing with a significant asset, you need to look at all sides of the tax consequences related to the transfer, whether it happens now through a gift or through your estate upon death. So taxation is very important. And I'm going to get to the number one practice tip related to the transfer of a cabin to beneficiaries, let's just say children or grandchildren. And that's funding. The best option, especially if you're giving an asset upon death, is to have some money set aside, what I call a cabin fund, from the estate that goes to provide for the carry costs for the first couple years. So let's say that I have a revocable trust, and that trust says the cabin to the kids in equal shares. I don't feel I need a cabin plan. It's just going to go outright to them. But I create a cabin fund so that 20 grand is set aside. So some assets from my estate that they haven't even received yet are set aside in a trust so that the first couple years the taxes are paid, the insurance is paid. They don't have to worry about going into their pockets. They don't have to worry about dragging money out from the other. It's set aside. Or what happens if I give the kids a cabin right now? I can still create a cabin fund in my estate so that whenever they need it down the road, there's money set aside. They don't have to go back and get money out of the other. It's just set aside. So that if they, by that time, they need a new roof, or by that time they want to buy the property next door, there are proceeds available. So the number one problem among co-owner beneficiaries is cost sharing. So if you set some assets aside in your estate, if it's something you care about and want them to retain long term, the best way to ensure that that works carefully and effectively is through setting aside some funds for the disposition of the property. Now, in a folder I gave you, and I don't think it's for those on the webcast, probably could make it available other ways. There are a couple pieces that are pretty valuable. One is a cabin planning discussion summary. So it basically gives a bunch of topics to be discussed at a meeting with your family or whoever's going to inherit the property. And it's an issue spotter. So you can kind of go through, some of it will be applicable to you and some of it won't. And then there's a checklist for cabin planning. And it basically goes through a laundry list of items that need to be reviewed and discussed by the interested parties while you're going through this planning. It's way too detailed and involved to get into right now, but there are some resources for you there. And if you have any questions, feel free to give me a call or shoot me a note. So I'll leave it at that. Are there any questions for those in attendance here?
Let me get the microphone real quick, just so our online audience can hear.
I have a cabin in Wisconsin, Dunn County, and then a home here in Hennepin County. I have filed with the county upon the death of myself and my wife. It goes to our 3 children equally. And that was done with less than $100. We just filed.
Mm-hmm.
And then what's the consequences if we don't have this additional planning that you're proposing for the cabin?
So
Maybe
that's
that maybe also apply to our home also, doesn't it?
yeah. So what you're talking about is what's called a transfer on death deed, which is no different than me saying upon my death, having it go just to the kids. So you're right, it's very efficient. It's like putting a beneficiary on your real estate. The consequence is it's back to this direct ownership issue where the kids, one, how does that deed read? Does it read in joint tenancy or as tenants in common? So meaning how are they legally going to take title to it? That's the first question. But with this approach, they're going to be co-owners and they're going to have to work out those issues we talked about. Who's going to pay expenses? Who's going to, there will be no succession plan. So if child number one wants to leave it to their neighbor, they can do that. There's no protection. It's not in the trust or in the LLC where it would be restricted. Now, they're not going to do that. They're probably going to leave it to their kids, and so you don't have that issue. But that's the risk. So with what you've done, it's very efficient. It's very important. You're avoiding probate with that transfer on death deed. So you'll ensure that it goes to the kids free and clear of any administration. But then it's going to be up to them to decide on how to get along and co-own that property.
Doesn't have to go to probate to do that?
No, because your transfer on death deed, you've designated the proper beneficiaries. So it's going to go to those parties directly.
Thank you.
So that's the primary benefit for what you've done.
And there's no 7-year rule.
So the 7-year rule, now you're talking about medical assistance planning. Talking about removing an asset from an estate so it's not counted for purposes of eligibility for nursing home care. Now, if I transfer the cabin to the kids today outright, that's a 5-year look back. If I transfer it to an irrevocable trust, that's a 7-year look back. So that's where your 7 years comes in.
So a
Todd doesn't do anything. You're not transferring anything until death.
till death.
Yeah.
Okay, but that cabin is still liable for
It's an asset,
its
Yep.
asset.
and it's not your personal residence, so primary residence. So they're going to basically say you're not eligible for us to pay for your nursing home care until you sell it.
Can you sell your primary residence since you're in a rest home anyway to help finance that further down the road?
Yeah, and well, what you want to do is you need to make sure that the cabin is homesteaded. So it is your primary residence because your primary residence is an asset that's exempt for medical assistance purposes. I could have a $500,000 cabin and I have zero assets for purposes of qualifying for a nursing home as long as that cabin is my homestead. It's public policy. The government says we're not going to take someone's home away from them because there's always the expectation of someone returning after being in a care facility. Do they? No, generally not. But what they can do is they can put a lien on it. So if my kids ever sell the cabin, they're still going to recoup their money. That's why they allow for that. But if you have a home and a cabin doesn't qualify as exempt. It's only your home that's exempt.
So it's almost better to make that your primary residence or homestead.
That's what a lot of people do.
And then
If
sell
it's
it.
worth more than your current resident.
Yeah. And now we're getting back into the estate planning discussion I had earlier about making sure you have the right incapacity planning documents, because if you wait too long and you go into that nursing home and you don't have the capacity to make those moves, re-homestead, sign off, then you're stuck. Then you can't do it.
If you've got a cabin in an LLC, but you don't have any agreements written up, does the state have set rules that you have to follow? Is it just like joint tenancy or?
No, well, so, it's a bit nebulous. It used to be stricter than it is now, but there are the formalities of a corporation. And if I'm a plaintiff's attorney and I want to sue somebody because of an accident, the first thing I'm going to ask them is, give me the corporate records. I want to make sure this is a valid corporation. and all of a sudden they can't give me those corporate records because there aren't any, I might be able to successfully argue it's really not a corporation. So at the very least, you should have the proper formation documents, articles of organization. That's what you file with the state to start the LLC. An operating agreement, which is akin to bylaws, as I mentioned earlier. The state more recently doesn't even require that you have minutes every year. In the past, they did. But it's not a bad idea to have them, because if you did get sued and all of a sudden you've got this pile of documents to turn over, that's pretty good. So the reason why it's a little foggy is that there's nothing that says if you don't have your corporate records in the statute that you're invalid. But it's easy for a plaintiff's attorney to argue you're invalid if you don't have all that stuff together. So the way to do that is just to get it in place. Those documents are pretty straightforward and basic. And there's no problem with creating them now, even though you filed the LLC years ago. Does that answer your question?
Yeah, in effect, the organizational documents that you submitted when you first formed the LLC, if I remember correctly, there was kind of a boilerplate organization agreement that that's all we used.
Yeah, but now, I mean, you might want to, some of those things I talked about earlier, I mean, you might want to have an operating agreement in there that makes sure it goes to the right, I mean, I don't know if you want to have your kids give it to their kids, but, spell it out. Or maybe have some buyout provisions in there. Get everybody together and talk about it. I mean, you could put a 6-page operating agreement and take care of what you need.
Okay, thank you.
Talked about gifting to children, 16,000. So if you have 3 kids, from my wife and myself, would be approximately almost 100,000. Can you gift the cabin to them?
Year after year?
5 years, then everything goes to them as a gift?
Yes, you could, but you're going to need a trust or an LLC to do that, because technically you could do it by deed, but if I give my kids close to $100,000, what percentage of that cabin is that? I have to do a fractional interest deed. Whereas if I put the cabin in an LLC, I can just put pen to paper and figure out what that is, and then that maybe means that they each get 6% of the cabin per year. And then next year I give them another certificate that says they're getting another 6%. We're not filing deeds with the county and trying to figure out what percentage or fractional interest they have, and then paying a couple $100 every time you file something with the county recorder's office. With the LLC, it's already in the LLC. You're just giving them a stock certificate that represents their share, and you do that every year. Yep.
What are the tax consequences for a Todd?
Nothing, because it's yours. You're not gifting it. Todd only says transfer on death, so it's basically a beneficiary designation. So there are no tax consequences. It's just like you owning it now.
For the previous owner and the new owners?
Right. Just like any other asset passing to someone upon your death. All right, anything else?
I do have a question too. So as far as the gift tax return goes, the 709 that you're talking about, do you need to file that if you deed the cabin to your children or gift it to them? Do you also have to file one if you put it into an LLC or irrevocable trust?
Yeah, because whatever portion of, depending on the formation of the LLC, if I'm giving them 100% of the LLC, then I've got to treat it as 100% value of that property. If I'm only giving them 50% of the LLC and I'm retaining the other 50%, then it's 50% of that cabin value. But yeah, any transfer, whether it's outright, in trust, or through an LLC, where I'm conveying ownership, it's whatever the percentage of that ownership I'm conveying that needs to go on that 709. And it's a good question, because how do you determine what the value is for that gift tax return? You need an appraisal. You can't just say the county says it's worth 500,000 and give the county assessed value. The IRS doesn't accept county assessed values because oftentimes they're not very accurate. So you have to engage an appraiser. Now, real estate, personal residence real estate appraisals aren't that expensive, but you still have to get one to certify the value and when you send the return in. Any other questions?
Would you advise filing a gift tax return even if it's not necessary? Because say you're, like the current year, you're giving away the equivalent of 10,000 per each to the kids. Would you advise filing it just in case to set that value in? Because after a few years, doesn't that become carved in stone?
Yeah, there's a 3-year statute of limitations when you file a gift tax return. So the annual exclusions, this 16 number, 17 next year, if that's what it ends up, that's a freebie. The government doesn't even mess with that. The only time it gets a little questionable is what's the asset that's transferring for 16? How did you value it? Did you give them a portion of real estate? And is there an appraisal for that? Sometimes people do, especially if they're doing a lot of $16,000 gifts. Like maybe I have 10 grandchildren and I'm given 160 grand and it's all maybe some low value partnership interest. I want to lock that value in with a gift tax return so they can't come back later and say it's worth $1 million, not 160. So on occasion, yes, but if you're just giving 10 grand in cash or, you know, giving people,
Speaking of property.
yeah. Yeah, I mean, you know, the downside to doing a gift tax return is it's either you're going to do it or a CPA is going to do it, and there's going to be some few bucks to file it, but you know, it's a no tax due return, so a lot of people file them just to get that clock running.
See, we had a cabin and it was my mother and my sister and myself. My mother passed away and we bought out my father. Actually, it was my stepfather because my father died when he was 46 and his wife had passed away. So my mother married her high school sweetheart. So my mother was married to him. So when she died, we bought him out. So now it was my sister and I. Now my sister passed away. So then her husband has it. So it's Doug and Jim and I. And then now, if in this case, we each get half, right?
It's it was in an LLC. Each one of the parties had a quarter interest. So when my sister-in-law passed away, her quarter interest went to her husband. So he has a 50% interest. We each have 25.
So now we have 5 children, and we have, one is getting married, so it'll be 4 married, 1 is not married, she's divorced. And then on the other side, there's 1 married person and 1 single. 2 grandchildren on that side and 5 grandchildren on our side. So, but it still is half each, right?
Well, yeah, but I mean, the best way for you to ensure that what happens reflects your intent is for you guys to get together, the 3 of you, right now, and hammer out an operating agreement. Because you can control who passes what on. Otherwise, you're just leaving it up to somebody's will or trust. Like I said earlier, someone could just leave it to the man on the moon or the neighbor or whoever, legally.
So what we would like to do is just ask the kids who wants to be in on this. Okay, so say 4 of them do and 1 doesn't.
Mm-hmm.
Then it would not go to their spouses. That's what I don't want it to go to
Well,
their spouses.
yeah, so what you need to do, one, you can have the LLC control that with the operating agreement, but then your will or trust needs to reflect the same, kind of back to the extension of an estate plan. So the one that doesn't want it, you can have equalization provisions in your estate that allow the one that's not getting the cabin to get more assets from other assets from the estate to balance it out. So that's how everything kind of ties back together. I mean, you guys are in a good spot because you already have the LLC in place. I think you just need to brush it up and then connect it to your estate plan.
So then, if, say, down the road, the oldest one decides, I don't want in on this anymore, then the others don't want to keep buying these people out. So then I would like it to say that that daughter could pass it on to her 2 children, or one of her 2 children, whichever one
Right.
wants it.
Or if you guys had the ability, meaning the capacity, you could just say, okay, we got 2 that don't want it and 3 that want it. We're going to give the LLC the cabin to the 3, and we're going to give other assets to the other 2, to increase their share. So whatever you want to do.
You can do whatever.
Yeah.
Okay.
The key is that you just make sure you do something.
Keep it in the family,
Yeah. Because if you don't do anything, then you don't know what's going to happen.
Well, my fear is that if it goes to and they all have great marriages, but you just never know. And I just don't feel that the spouse who is not an immediate part of the family or blood related should be involved in this.
Yeah. Hey,
He should be out of it.
I've been married 26 years, and my parents like my wife more than they like me. She's not a beneficiary of their trust.
Yeah.
Bloodlines. I mean, that's the default in the law. That's how most of these documents are done. The spouse is excluded. That's just normal. Anything else? All right.
How did the spouses, their family get into the inheritance of the cabin they were talking about?
Yeah, well, it just went by will to the surviving spouse. If they would have had an operating agreement that prevented that and said it went to the kids only.
Probably the will didn't say that her husband was included, but no, her husband is included now.
Yeah, well, that's just because they didn't have the documents in place. They had the LLC, they just didn't have anything that restricted transfer.
All right, David, thank you very much. Greatly appreciate you being here, taking time. Thank you all for coming. Thanks all of you that are online. Again, David Ness with Fafinski, Mark and Johnson, very reputable firm. Like I said, we have the utmost confidence in them and the work that they do. Been great partners of ours. And if you have any questions, I think everybody here in person has the information. For those of you online that need it, let us know here at Secured Retirement, or we can certainly get you in contact. So with that, thank you all and enjoy the rest of your day.